All right, welcome to MazzaMedia. I am Mark. We are live for the second time today. The first stream went down, so now we're going to try to redo another stream in hopes that this stream will work better than the last stream. So we're going to go ahead and take a quick look at that now and see if this works and see if this is much better in the chat so we can do a show today and raise some money for Kelsey Fitzsimmons. Hope everybody's doing well. And I'm just going to check the stream here. Everything sounds good. Yeah, everything sounds good. All right, so that's fantastic news. I just did a quick Red House Media, what's going on? Jessica, what's going on? Yeah, I just did a quick internet connection adjustment too. So I basically shut my internet off and rebooted it basically. So that's what I ended up doing. So new stream, back up live. Thank you guys for tuning back in with me today. And we're live. Afternoon show, final show of the month of November. We're moving on to December already, if you guys can believe it. Cannot believe it, but here we are, and here we go. So we're going to be talking about Kelsey Fitzsimmons today throughout the afternoon and talking about what's going on with her. As you guys know, she's still in jail in Western Massachusetts in Chicopee, of course, and did not spend Thanksgiving at home with her family. Her birthday and Thanksgiving were spent in jail. Which was not good. Rhonda, good afternoon. How are you? Diane, hope you're doing well. No, actually, you're saying hello to Rat House. Interesting choice of the emojis there to say hello to Rat House. That's funny right there. But yeah, not good for her. Not good for her as well. Not good for her family. This is a very sad situation, of course, and something that doesn't make me very happy. I think that a lot of things could have been done differently to prevent all of this, as you guys know. And today, we're going to be recapping some videos here to go over exactly what went down and how court was this particular week and have that discussion and go over all of that. So the Patriots are not on today, so I can do an afternoon show, which is really good. Usually I sometimes do my shows after the Patriots are on, but this weekend they're on Monday Night Football. All right, so the Giants-Patriots tomorrow night. Big game tomorrow, of course, going down at Gillette Stadium. Wish I could be there, but I won't be there. But, the Bills are playing today as well. I haven't paid any attention to football all day long, to be honest with you. I watched a lot of it. I watched every game on Thanksgiving. Every single game on Thanksgiving. I watched Michigan-Ohio State yesterday in college, which was good. Bengals had a pretty solid game against the Ravens. There on Thursday night as well. Yeah, but definitely this is a tough situation for Kelsey. It's a tough situation for her family. And in a lot of ways, the stage was set, prior to everything going down with them. What I still can't get over is the fact that they did not try to acquire all the weapons in the house first. That's the one thing that continues to stick in my mind, is that they wouldn't ensure. I had an anti-Kelsey Fitzsimmons person confront me. I blocked them. Of course I did. I always block people that are anti-Karen Reed and anti-Kelsey Fitzsimmons. They came at me and they're like, well, she did what she did. And I'm like, do you understand for a second that they did not sweep the house for firearms prior to doing what they did? They allowed her to be in a one-on-one isolated situation. These officers didn't do their job. It's absolutely sickening that this all could. Like I said, at the end of the day, no matter what way we cut this is essentially a one-on-one situation, meaning they allowed it to come down to one cop and one person being served an RO and allowed that situation to potentially get out of control. Now, obviously, I believe Kelsey that she put the gun to her own head, not pointed at the officer. I totally believe that narrative. But even that should have been prevented by the North Andover Police Department. And questions need to be asked as to why they didn't do everything in their power to try to prevent that from happening. They should have gone in the house, located all the firearms before they moved anybody around the house, before they allowed anybody in the house additionally, located them, seized them. Okay, now we're going to take care of the packing of the baby stuff, the baby, bottles, all that stuff next. That's what they should have done. But they didn't do that. They allowed Kelsey to go around the house. They had not located the firearms first. They had not protected everybody. That's the one thing that really stands out to me in all of this is how in the world did they not take preventative measures to ensure everyone's safety, including Kelsey's? Why would you ever allow this to ever get to that point? And I feel like because these officers either did this by being negligent or over trusting, or these officers, the fix was in, whichever narrative you'd like to believe, it shocks me that they wouldn't secure firearms first and make sure that that was all taken care of first. And then at that point, start to move things in a direction, we're okay. Well, now we'll move around the house, but instead it leaves everything up to chance. And Officer Noonan found himself in a situation where things could have gone negative for him as well, right? He had to discharge his firearm, all that stuff, not good for him, right? Unless he did it on purpose. I personally just think that she pulled the firearm and he panicked or reacted. Some people think that, this was a setup. This was a total, they went in there, like someone said here, the fix was in. A lot of people believe that too. But I think at the end of the day, they could have secured all the firearms in the house and this would be a totally different situation. At the end of the day, this should really just be a child custody battle. This should be your standard child custody battle between Kelsey and Justin. That's what it should be. It should be, I want the child, blah, blah, blah. We're going to battle over our child. But then this becomes a situation. This is why people think, you see Jess in the comments here. She thinks this was a setup from the beginning. People think that, and they're right to think that, because it's plausible that there was a fix in to basically put Kelsey in a situation where she'd do stuff that might place her in a situation where she doesn't get this child ever again, And that's kind of what's happening now, isn't it? Kelsey Fitzsimmons is in lockdown. She's in jail in Western Massachusetts. She's missed her own birthday. She's missed Thanksgiving. And as it stands, you can bet on Christmas and New Year's as well. And it's an extremely painful situation to watch. And I think everybody that's already donated to the fundraiser so far, I see 2 donations already rolling in. Another one just came in too, rolling in right now. So we're starting to get those fundraisers. We're already up to $60 already. It looks like 3 donations are coming in already. It looks like 3 $20 donations roughly have already rolled in. So that's fantastic. But yeah, I just think that it should have been a simple child custody battle. And here we are where this is absolutely, that's okay. We count everything, Diane. Everything. So what I do is I take the total that's there before the show and I just add everything that comes in. So your 20 is counted. Thank you, Diane, for helping out Kelsey Fitzsimmons and just assuring her an opportunity to defend herself and have the funds that she needs. But that'll be good. That'll be good. Any contribution people can make. This wasn't a planned fundraiser. I have a more formalized fundraiser that's planning to be next Sunday. That's the plan right now. Next Sunday is the plan for a really big one. I'm trying to get some guests on that program. I want to try to get a high-profile lawyer on the show as well. So I have a few high-profile lawyers that are on YouTube. At least one of them I'm trying to narrow down to get them on the show for next Sunday. So I'm going to try to do that. I have a few emails that have gone out already, and then I'm working on a few others as well. I believe that's her mascara, Laura. That's my belief. But I'm not sure if it was you that had asked that on Twitter, but someone else asked that of me on Twitter. I'm not sure if that was you or someone else, but there was some concern raised about that as well. I think it might have been just the mascara potentially, but I'm not sure. So yeah, I'm going to try to get an attorney on the show. I want to try to have an attorney just to talk about more of this stuff. And what I really want to know, I just think having attorneys on these fundraisers are huge because they help bring more attention to the show, which drives in more funds for Kelsey. And then it allows everyone in the chat to ask questions as well as this goes moment to moment. with changes and what's going on with Kelsey and her fight to get out of jail at this particular point, which is getting tiresome, which is what I hate about a lot of the cases here in Massachusetts, whether it's Karen Reed, whether it's Turtle Boy, whether it's Kelsey Fitzsimmons, whether it's any other case that's going on. There seems to be an elongation of resolution in a lot of ways where you think that resolution can come quicker. And whatever side of the aisle you're on, and I know there's a lot going on right now out there on Twitter. I know there's a lot of, people going back and forth on what sides we should be on. But I think at the end of the day, we're seeing multiple individuals that are facing charges or civil charges or faced criminal trials in the past recently that are battling through everything and seeing a system that's really been very hard on them and has really been problematic to them as well in terms of getting resolution. And we're seeing the same thing again here with Kelsey Fitzsimmons, where she is pushing and fighting and trying to do everything she can to stay at home, to, at the very least, worst case scenario, be in house arrest. If she was under house arrest, I think that, she could have still spent Thanksgiving with her family, no problem at all. Had her birthday with her family, no problem at all. Instead of them having limited time to talk to her. I think they only have like 2 hours a week. And we're going to play some of Justice Serves video later in the program and go over that as well. And try to get some, go over this again, go over what happened in court this week and talk about it some more and, try to get some more understanding of what the resolution process here is going to be. But my problem, too, is I just feel like these judges, they're very locked down on how they see that they're going to handle everything. They're going to lock everything down in terms of how they want to handle the situation, how they want to look at the situation. And that's been very, very difficult as well to watch, just because, again, especially when we're people of belief systems, meaning we believe in the innocence of a lot of people out there. We believe some of these people have been, if not all of them, have been overcharged. We believe their charges should go away. Yet, here they still remain. Here Kelsey remains in jail at this hour and for the foreseeable future, which is difficult to watch, of course. So we're going to go over what happened in court on the 25th, 5 days ago. We're going to start talking over this, and we are going to see if this will share, which it does. And there we go. All right, let's go with this. All right, so we'll go with this. Which link do we want to go with? Let's go with that. There we go. All right, so donations up. What I need to do is this. I need to do this. No, not that. This. Perfect. And then I'm going to get the GiveSendGo on the screen. All right, we'll do that. All right, good. Now we got that all set up. I had a great holiday. Too much bad stuff. I just had the final piece of pumpkin pie that I had at my disposal before the show. All right, we're now up to $80 in donations. And a lot of $20 donations are rolling in right now, which is huge. They're all adding up. So $80 raised so far for Kelsey. And let's get this thing rolling. Here we go.
Call number 22 on the list, Commonwealth versus Kelsey Fitzsimmons. Doc number 2577, Geoffrey 11.
Hello, Your Honor. Timothy Bradle on behalf of Kelsey Fitzsimmons.
Good afternoon, Your Honor. Martha School again.
So one of the things I want to talk about before we get rolling here is why Kelsey's there. This is standard protocol. She wasn't changing her plea. So she was kept out of the chair and just kind of in this containment area on Tuesday. Just because of that's how they proceed here. So this was nothing out of the ordinary. Bradle had petitioned for her to sit with him because he wanted to talk with her. But that was not allowed because no change of plea was taking place. So people on X were kind of coming at me. These were not your typical supporters of Kelsey. They were your antis, basically. And they're like, Mazza, you don't know what you're talking about. This is pretty standard. This is pretty standard. I'm like, all I did was say online was that Kelsey couldn't sit with her attorney because that's what the judge ordered. And all I did was explain what the judge said. So some people online were trying to make it seem like I was trying to make like a controversy out of this or make this seem like this was a big scandal. No, it's just I was just kind of explaining why this was happening. People are trying to make it seem like I was crying about it. I'm like, no, it's just sometimes you just can't say things simplistically online. People are like, yeah, he's just giving an overview, like a caption, like Kelsey could not sit with her attorney because of this reason. Ridiculous. That's okay. All right, continuing here.
Yes, as well. All right, good afternoon.
Judge, can I ask as a preliminary matter, Ms. Kelsey might be permitted to join us? Ms. Fitzsimmons might be permitted to join us.
No, I only do that for a change of plea, a trial, or an evidentiary motion to suppress, and I don't see why I should treat her any different than anybody else. So the answer is she's here at your request, but no one can let her sit in counsel. Otherwise, I have to allow that for everyone, and it presents a security concern. So if I do it for one person, I have to be consistent.
All right, if I need some time with our judge, I'm just going to support you.
Which, of course you can. You can go talk to her, which is your time. Okay, so this is on for trial assignment today. I indicated in the phone conference that we had back in October that we could try it anytime. And so let's do that.
So Judge, a couple of things on that. We think that's a little premature for several reasons. I have 3 outstanding discovery motions, but that we should go on to talk about today. If it's already recorded, that sort of are, stepping stones to getting ready for trial.
Have you filed?
Yes.
Okay, let me see it.
So 2 of them were filed on August 26th.
Okay,
And the other one is, and I'm certainly happy to give counsel for some leeway. This was filed, I believe, last week, November 21st. And so if counsel needs more time on that, I certainly don't have a problem with it. But, and I will grant you, I'll acknowledge that counsel's given me a pretty fair amount of information that we're going through. But as you can imagine, as I know, that sort of begs further questions about more discovery.
well, I have one motion here for specific discovery.
Well, Judge, we filed 2 motions on August 26th, and I have copies of them here.
And what are they entitled?
There's a motion for court order disclosure and relief of arraignment, and there's a motion for you to sign.
Okay.
Serving Brockton and surrounding.
The Commonwealth may well be in compliance with some of that or most of it, but.
Yeah.
And so, those are really the first ones, Judge.
What is that?
Sorry.
Okay, camera is allowed in the courtroom, but it has to be silent, no exceptions. Thank you.
So the first one is the motion for exculpatory discovery, and
Yeah, the technical difficulty on that was pretty wild. Everyone's like, what's that noise? Oh, my ears. The audio did sound off though for a while there, which was totally nutty, but
that is
now it's back.
essentially a Graham McFarland request regarding certifications by the officers, whether there's any prior incidents. And that is a predicate to a Rule 17 for that, so that we have a good faith basis, if any, to file a Rule 17 for any further information. And my brother's telling me that that's fully complied with.
Okay.
It's a tough image to watch on this screen. It really is a tough image to watch. You see Kelsey in the background there, and absolutely confined to that room, which is tough to watch. It's a tough visual. It really is, especially when we all so strongly believe in her innocence, or in her justification, meaning that yes, she put a weapon to her own head, but 2, she had postpartum depression at the time. So it's very tough to watch this visual and see this visual of her back there, just clamoring for any level of any level of any level of hope that she can possibly clamor onto, and just feeling like there's just no hope. That's no matter what happens, they've escorted her here to court for this day. She's going back. and she's missing the Thanksgiving holiday. It's tough to see that happen. It definitely is, and it's definitely rough, and it is tough. There's no question about it.
And I have, but I'll defer to him on that.
Okay,
No, I think I can comply with my obligations under the.
okay,
As far as that first motion, there are things in there in the first motion that I did not agree to,
okay.
and we can go through that if we like, but other than that, we have a list of questions that we ask every potential witness, police officer.
Right.
The database, that has all been complied with.
Okay,
If he wants to talk about the first motion, I'm happy to do that. No action has been taken.
which, when you say first, I've got three motions here.
Motion for exculpatory evidence.
Okay,
Exculpatory discovery.
So that's essentially what we're talking about, Judge, the Graham McFarland request. And, you know, it's also obviously a Brady request as well. So I think it's more than just, you know, Graham McFarland. It's any exculpatory evidence that's known to the Commonwealth, whether it's the Commonwealth, the prosecution team, or
well,
the police team as well.
so Mr. Gubitosi, the motion for exculpatory discovery,
Yes.
what is it that you object to in
I
there?
object to number 1C,
Okay,
number 1D, number 1H,
okay, hold on.
and J.
C, D, H, I, and J.
And then that's number 1.
Right,
Number 2,
So everyone seems to think that this is eye bruising. I don't see that. I just think that it's mascara running down her eyes. You know, she's got makeup on, and I think that's just dark makeup, and it's just kind of going underneath her eyes there, and it makes it seem like she's been bruised and beaten up. But my understanding, this is what I've read, is that she's in solitary. So she's basically cordoned off from population and all that, from what I understand, because they're trying to protect her because she's a police officer too. You know, last thing they want is a cop being able to be circulated among, you know, all the inmates that have been arrested by cops that want to beat the living crap out of a cop. You know what I'm saying? So they got her protected. That's my understanding.
you want them to certify in writing that I have made inquiry of every prosecutor in my office for all items of information. I don't think I have an obligation to do that.
right.
We did that on every single case. We do have a database. We do have a process. We do ask each individual officer these questions, but we do that on every
Yeah, I don't see any bruising.
case.
Right.
There'd be a level of puffiness in her face as well. You know, you'd see if she had been punched in the face, there'd be, again, a lot of inflammation. Their face looks very natural. There's no puffiness. There's no inflammation. There's no bruising. That would be, you know, this is just having like a generalized bruise, which means just colorized, but there's a difference between actually getting punched in the face and actually having what will look like an egg puffing out of your face, you know, but that's not the case here. Her face looks completely natural, no abnormalities at all. And again, just the mascara. She's crying. That's what it is. I mean, she's very upset, obviously, and I don't blame her.
In the county, that's thousands of cases to some 80 some odd prosecutors.
Right.
Every day.
Well, and it doesn't include all of the prosecutors.
Hey, there's no Patriots on today, Mark. We're good. We're good. We're good. We don't got no Patriots today. Patriots Giants tomorrow. So yeah, during the NFL, yeah. I had my wings last night. I'm good. I'm good to go. I'm good. We're good.
Prosecutors that have passed through the office that have come and gone over the course of the years. Are you suggesting, Mr. Bradel, that the Commonwealth needs to contact each and every prosecutor that has ever worked in the district attorney's office throughout the officer's tenure?
No, Judge.
Well, that's what the motion asks for.
No, it doesn't, Judge. It asks them to have, maybe they could use a computer database. Maybe they can log, just like, you know, lawyers have record keeping responsibilities. Lawyers have conflict checks. There's all sorts of things that are a precedent for this kind of a thing. When a prosecutor has a case where some questionable police activity has arisen, prosecutors can easily document that in this case, Officer Jones was found to be not credible by Judge Smith.
Well, I understand that, but let me start with whether the officer has signed a search warrant. I probably see 2 Frank's hearing requests a month in this session? 2 or 3?
Today officially marks
I really got to switch to premium, but I'm so stubborn I won't do it. But I swear to God, those people in that commercial was talking about being in no contact with their parents, and I don't understand why. We probably should have let that advertisement play. Now I'm curious about what that ad was about. Like, I've been in no contact with my parents for 30. It's like, what the hell? No, this judge is basically favorable to cops, it seems. Melanie Little talked about that this week as well. He has a history of being more favorable towards police officers. I know. I donate to Need Maz's YouTube Premium Fund. I'm so stubborn with that. I don't know. I've always been stubborn like that. I don't know why. You know what it is? I got so many other things I pay for. I pay for Netflix and Paramount Plus and Peacock and Netflix and Prime. And I'm like, I got to pay for YouTube now. I'm like, oh. It's how many apps do I got to pay for? You know what I mean? You know, I like to play these videos, but YouTube's layered with so many commercials all the time. Oh man, I hate it. I hate it. But that's exactly right here, and I like this point. That's fine, but she's a cop too, and I think that's another issue that we had argued oftentimes in the Karen Reed case is that John O'Keefe is also a cop. You know, it's cops against cops once again. So download Meld Streaming. It's free and it's incredible. All right. That's all good. All right. Let's get this. Do a midweek non-fundraiser stream and link your Venmo or something. Yeah, exactly. The MazzaMedia YouTube Premium Fund is underway. Yeah. We need help for Mazza. We need help for Mazza.
Most of them are not allowed. Occasionally they are. And just because there is a Frank's hearing does not mean that there was a finding that anyone gave any false information.
Sure.
So how would anyone determine that?
Well, Judge, again, these are record keeping requests.
But who keeps a database of that
So
for the last 10 years?
when you're a prosecutor in a district attorney's office and you finish a case, you're required to follow office procedures to close out the file.
Right.
And there's no reason why a prosecutor's office ought to exercise willful blindness about these issues.
So you feel that it's up to you to decide how the district attorney's office conducts its business?
So this is what grinds my gears. This is what gets under my skin a little bit. Is I often feel sometimes these judges, while they are in positions of power, while it is their courtroom, while it is their duty to do what they deem necessary to run their courtroom, what gets me a little flustered is that, you know, he's starting to kind of undermine Brado a little bit, you know, there, which I don't appreciate because I feel like that gets off message where the judge is now engaging in a back and forth battle of the minds with defense attorney Tim Bradel here. And so you think that such and such, such and such and such and such, you know, and you think that this is, you know, you think it should be that. And that it's like, I don't want to see a judge do that. I would like the judge to say something a little bit less condescending and a little bit more progressing of the conversation here. Instead of trying to get into it with Bradel, trying to chomp at the bits with Bradel, trying to act like Bradel is whatever, that always causes to me a little bit more of a turbulent courtroom. And I don't like that. I wish the judge would be a little bit more, I don't know, word that better maybe. Let's play it back.
Ought to exercise willful blindness about these issues.
So you,
Procedures to close out the file.
right.
And there's no reason why a prosecutor's office ought to exercise willful blindness about these issues.
So you feel that it's up to you to decide how the district attorney's office conducts its business?
So he doesn't like the fact that he took a shot at the district attorney's office. But I just feel like Bradel wants to have access to everything that he possibly can. And Bradel's questioning the process here because, once again, as we've seen in multiple cases, all the ones you're familiar with, the Karen Reed, your Turtle Boys, you know, you've seen a situation where there's been a battle for information or a battle for access, or Bradel feeling when he defends Aiden. or Alan Jackson and David Denny when they defend Karen Reed, feeling like we would like to have all the access to the information we would like, but we do not feel like we're getting that. And you see Bradel here in this very same situation once again, where he's taking on the judge in a respectful manner to say, hey, we would like to have certain access here. We would like to have certain things at our disposal. We don't think we're getting all the information that we particularly need. And then the judge is getting a little condescending there because, like, I don't know, just weird.
It's up to me to
Did you work in the Essex County DA?
So he starts taking shots at him here.
Judge, I did not work in the
Okay,
Essex County
so
Attorney's office, but I do
From
know
when, sir,
about it.
what are you speaking about when you say that this is how a DA's office ought to be conducting itself? What's the basis for that?
Judge, I don't think it's an obscure proposition, Your Honor, that when a public agency such as the district attorney's office has to close out a case, that they have to comply with record keeping obligations under the law. Under FOIA, under record keeping for all sorts of things about what happened with the case.
Well, I understand, but Mr. Gubitosi has represented that he's gone back and searched. They have a process. I'm sure that he'll advise you as to what the process is. And if you want to critique the process, that's up to you. But in terms of them producing evidence that is in their possession, custody, and control, he can only produce what he can search for. And the fact
I think that the issue here, and this is my interpretation of this, is I feel like Bradel is almost feeling like this is another situation, even similar to Karen Reed's case, where the prosecution and the DA's office are not being trusted. And I think that that's where we're here is, again, he's asking for information and they saying, Your Honor, look, we want access to this. But, the judge is kind of like, well, the DA's office can only look up what the DA's office can look up. The prosecutor can only look up what the prosecutor can look up, which I think to Tim Bradel means that, well, are we explaining this away, though, respectfully, is that are we in a situation where we can get information, or is that information existing, but yet it's not being provided, but yet it's being explained away as, well, they can't find it. They can only find what they can find. And I think that there's a level right now out there among a lot of us where we're just not trusting the system right now. We're not trusting the system in a lot of these cases. And we're like, well, are we going to get everything we need? It's like, I'm at the point now too, where it's like, I don't trust this anymore. I don't trust it. And it's like, I want to trust it. I don't want to not believe that we can't trust people. But at the same time, someone like Bradel's sitting here, he's arguing for information and it's not being provided. Then it's like, well, if they don't have it, they don't have it, Tim. And it's frustrating now because you don't, in these sets of circumstances, and this is a second cop versus cop matter that we've been talking about, a lot of us, Karen and John O'Keefe against the McAlberts, and now Kelsey Fitzsimmons versus the North Andover Police Department. And we're all kind of sitting there and it's like, can we trust this? Do they really have this information and they're not providing it? That's where a lot of us kind of get caught up a lot of the time and say to ourselves, are they really telling the truth? Can the prosecutor really be trusted? Can the DA's office really be trusted here? And it's just tough. It's just very tough.
fact that you disagree, maybe you do, with the way in which they keep records or the type of records that they keep is not an issue that I'm going to decide. I don't know of any case law that says that I'm the one, or you for that matter, to decide how the district attorney's office keeps records. And in fact,
well, that's what I think is bothersome, though, is this is not a critique of the judge here, to be clear. This is more of a critique of the justice system. Am I to understand that the DA's office has their own parameters and means to determine how they operate and how they file everything away? Meaning, are there no laws? Is there no regulation? Is there no oversight into how a DA's office conducts itself? Meaning a DA's office can have or not have any information that it pleases. It can dispose of information as it pleases. It can produce information as it pleases, and that there's no regulation of that process. I think that's what bothers me here is that so? Is that true? Where are the checks and balances in all of this? Those are things that bother me. Those are the questions I begin to ask.
I'm not going to order anybody to retroactively go back and search records from, I don't know how long the officers who are witnesses in this case have been police officers in this county, but do you know, Mr. Gubitosi, off the top of your head?
And one of them's 20-something years.
Yeah, so I'm not sure that I can ask them to search records they don't have, but there is whether the officer has ever attended or presented at a law enforcement training by the private vendor.
Judge, before we jump off of that one,
Yeah,
all the Commonwealth has to do is ask the officers. There was 4 officers that were at the scene.
right.
They can ask 4 officers, were you ever involved in a Frank's hearing? There are ways to do this. You don't have to act like this is some obscure thing, Your Honor.
So that's, again, Bradel making sense. Tim Bradel makes a lot of sense. Tim Bradel always has a means or an avenue to counter the judge's, he'll ask the court for something. And the judge will be like, well, no, we can't. And then Bradel always kind of has that way to circumvent and switch avenues and find a way to re-ask the same request and talk about how it can be done. I always enjoy listening to him when he does this and gets that going. Let's take a look at the Kelsey Fitzsimmons fundraiser. All right, we are at $105 so far. Very good, very good. $105 donated to Kelsey Fitzsimmons fundraiser so far. And it's over $46,000. That's really good news. And it's $46,755 total, with $105 coming from this show today. Very good job, ladies and gentlemen. And our overall for MazzaMedia shows is getting up there as well. So it's over $10,000, $10,624 so far, which is great news. So we're getting there. We're getting there, ladies and gentlemen. We are getting there. Let's continue with this.
This is exculpatory evidence. We have every right to all of these things under Graham McFarland and under Brady.
So Bradel, again, making sense. Again, we should have access to this. We should have access to that. And thank you so much, Diane. I appreciate that. Go back up here. But that's the problem. He always has to get into it with these judges about every little thing. Every little thing he's going to get into it, just for arguing over the right, not for arguing even the freedom of his client, but just arguing for information here. The constant argument for information.
Ask the officers. There was 4 officers that were at the scene.
Right.
They can ask 4 officers, were you ever involved in a Frank's hearing? There are ways to do this. You don't have to act like this is some obscure thing, Your Honor.
This is exculpatory evidence. We have every right to all of these things under Graham McFarland and under Brady.
What case says you have a right to find out whether any police officer on any case has ever refused to answer questions?
A police officer in our case, Your Honor.
No. In this case, what is the precedent? You've got to cite, where is the case or statute that says that a police department has to disclose to you or to anyone else when an officer declines to answer questions? There are a lot of reasons for that, I can assure you. And I'm not.
Yeah. Bradel looks down. Bradel looks down here, and he just looks down like, man, watch Bradel here closely.
Police department has to disclose to you or to anyone else when an officer declines to answer questions. There are a lot of reasons for that, I can assure you. And
right
I'm
there,
not aware.
He smirks his ass off and just goes. Bradel just goes just like this. Bradel's just like that. Like, don't bullshit me. Don't bullshit me. That's what he's like right there. Bradel just smirks. Like, stop. I mean,
Department has to disclose to you or to anyone else when an officer declines to answer questions. There are a lot of reasons for that, I can assure you. And I'm not aware of.
He dips his head and just smiles like, come on. Come on. It's not It's explaining away, and I don't like it.
Police officer in our case, Your Honor.
No. In this case, what is the precedent? You've got to cite, where is the case or statute that says that a police department has to disclose to you or to anyone else when an officer declines to answer questions? There are a lot of reasons for that, I can assure you.
So the problem right here,
And
kind of gets,
I'm not aware of any record.
is there's a lot of reasons for that. I assure you, is the judge responds with a generalized reply here, which is, well, there's a lot of reasons. There's a lot of reasons why they might not have done that. That's not a sufficient response. And that's why you see Tim Bradel kind of smirk and laugh the way he does at that point, because he's just the judge is making a generalized exception for why these cops may or may not have answered all those questions. And that's the situation here that's happening. I don't think Bradel or anyone else wants to see the judge try to make a justification for why. I think we want to know the concrete reason as to why, as it pertains to the actual officers involved on the scene. And I think that's the difference here. And I think that's why Bradel smirks, because it's like it comes off as favoritism towards the officer. Well, there's a lot of reasons why. There's a lot of reasons why. Well, that's not what we're looking for, Your Honor. We're looking for an actual interpretation, an actual reason, not like a, well, a lot of times, this can happen in a lot of cases that I handle. We don't want an estimation. We want every single case looked at on a case-by-case basis with an individual take and perspective on those cases individually, and not just a justification of, well, most of the time in most cases, that's not what we're looking for here. And that's why I kind of get a little discouraged listening to some of these judges. I don't want to ever tear apart a judge entirely or on every level, but I do want to critique on a level that I deem necessary. And in this particular case, I don't like that comment. I don't think Bradel liked that comment either, because it was explaining away and it was justifying, and it wasn't looking at everything at a concrete level. And I think that's kind of why Bradel smirked the way he did, with the kind of the FU attitude he had there.
Records that are kept of that. And I can assure you that it would never be admissible under any circumstances. So I'm having a hard time with the concept that the DA's office or the police department has to supply you with the fact that an officer 15 years ago declined to answer questions after a shooting at the scene, but 2 days later answered the questions, for example. Happens quite frequently. So I am reluctant to say, I doubt there's any police agency that keeps records like that. I don't know of any, but certainly the district attorney's office doesn't keep records like that.
Your Honor, I certainly am not telling you anything you don't know, but just put it out there on the record. When an officer,
I like the way Bradel kind of agrees with the judge prior to pivoting. Thank you so much, North Shore Girl, $4.99. Appreciate the coverage. Thank you so much for tuning in today. And I appreciate everyone that's taking time to tune in, making a donation to Kelsey Fitzsimmons by going to our GiveSendGo as well during today's fundraiser. And if you guys can just continue to spread awareness as well for that GiveSendGo, that's appreciated. But North Shore Girl, thank you so much for your super chat today. And as Jess says, thank you for your channel support as well. Greatly appreciated. Thank you so much, North Shore Girl. But I like the pivot here by Bradel. He kind of agrees, like he concedes some things to the judge. Your Honor, I'm not trying to get into it with you, but there is certain information that we are looking to. I'm going to see if I can get a count here on the GiveSendGo. Ooh, we got a nice donation coming in here. A couple of them, maybe. Let's see. Looks like a couple of them have come in. All right, let's get a new total here. I think we went up $90. Let's see. Let's make sure I get the right number in there. $845. $195 total so far. Fantastic job, everybody. $195 for Kelsey Fitzsimmons. We are $5 away from hitting the $200 mark on today's fundraiser, which is fantastic. Great work. We'll keep it up here and continue to make things move forward here for Kelsey in the best way we can. Let's continue with Bradel and the judge.
The attorney's office doesn't keep records like that.
Your Honor, I certainly am not telling you anything you don't know, but just put it out there on the record. When an officer takes the fifth, so to speak, it's been found that a truthful answer would incriminate them. So it's incriminating information.
Who's made that finding? That's an interesting concept because I probably represented thousands of officers at interviews, and I yet to have or even hear of someone making a determination that that person had a Fifth Amendment privilege or not. My experience has been that the department offers people a rights form.
That kind of really set off Melanie Little this week, those comments where he goes, I've represented thousands of cops. I don't think a generalized response here is what a lot of people appreciate. We want to look at everything on a case-by-case basis. I think that's what frustrated Melanie. And I think that's probably what frustrated Bradel and probably a lot of other people this week as well. It's just that generalized response.
And if the department has made or ascertained that the person has a self-incrimination right, far be it from a lawyer to question that when the prosecuting or investigating agency is doing that. So again,
It's built into the law of the Fifth Amendment, Your Honor, that you can only take the Fifth Amendment when a truthful answer will incriminate you.
that's assuming you're ordered to, and that's assuming that the order also encompasses the nuances presented by the state constitution, which requires transactional immunity to overcome it under Carney versus Springfield. So it's not as simple as you make it sound. But let's get back to the fundamental issue. Does the district attorney's office keep records of any officers that have ever invoked their rights at any proceeding that the district attorney's office is aware of?
No.
Okay. And
So it's a simple softball here. Does the district attorney's office do this, do that? The prosecutor says, nope, moving on.
with regard to the police department, Mr. Bradel, I'm not aware of whether they keep records of that.
You know, I'm going to take on this comment here because I like it. Not this comment. This comment here. JBZ18 writes, are all these judges corrupt? I ask. You know, I don't necessarily think. I would say this. I would say that I think that they are gatekeepers of government, and that pertains to the judicial system and what the best interests, not our interests, but the best interests of the state and judicial system are, and our policing system are. When we look at Commissioner Cox and the Boston Police Department, or what's gone on in Canton, North Andover, the state police, for example, both situations appear to be, Karen and Kelsey, both appear to be cops against cops, or at some point, thank you, Sophia. We'll get that donation counted in moments. Appreciate it greatly. Yeah, it is a mild way of putting it. Yeah, it is, but that's how I'm going to put it. But I feel like there is a way of trying to maintain man behind the curtain, like in The Wizard of Oz. Nothing to see here. Pay no attention behind to that man behind the curtain. And a way of just trying to dress up everything to not make it seem as what it was to the public. Meaning, Kelsey Fitzsimmons has a strong argument. Karen Reed has a strong argument. John O'Keefe has a strong argument, right? In terms of what went on, how it went down, and the accountability of people that responded to crime scenes and all of that. And I think that these judges, what I'm saying is I don't think that these judges that are angering us so much are always this way in every case. In other words, if you sat down and watched them in more casual cases, you'd probably be like, not bad, you know. But I think in situations like this that are so involved with police and police procedure, and even a high degree of controversy pertaining to these officers and how they conduct themselves in both cases, I think that these judges are playing favor to those in authority. And that's been my attitude throughout a lot of these cases. Is I feel, what I'm saying is I don't think these judges are necessarily every single case you know, I'm sure if we sat down for more common cases, you know, okay, maybe Judge Bev wasn't so bad there. Maybe this judge, you know, Dreschel is not so bad in other cases. But when it comes to this cops versus cop stuff, there's something there. There's something behind the scenes where the governor or police commissioners or people in charge at certain levels, they're trying to contain or confine this stuff. I even felt the same way about Enrique Delgado Garcia, where I felt that they kind of kept a lot of stuff under the radar as much as they possibly could. And it seems to me that someone like Bradel is always kind of taking on situations that pertain to these kind of matters. You've seen it with Aiden. You've seen that with Karen Reed's defense attorneys, you know, where they're all taking on a situation like this. And it seems like that's what we're always watching is cases like this. And there's that constant sense of the Massachusetts State Police did everything they could. Even Commissioner Cox, the Boston Police Department, tried to do everything they could to be as disillusioned to this stuff as much as they could. Till the public pressure came in, and when the public pressure came in, they had to start taking care of people by firing them or rehoming them. You know, and I think that that's what's happening here too. Is that this judge is essentially gatekeeping for the police. He's almost like a judge who's also a police advocate at the same particular time. This being a cop against cop matter as well, to a very high level where he had an officer shot, you know, which is Kelsey Fitzsimmons, an officer arrested, which is Kelsey Fitzsimmons. And it just seems to me that every time Tim Bradel tries to peer behind that curtain and get to the bottom of what's happening, these judges are like, no, Mr. Bradel, no, that's no, the DA's office, no, the North Andover Police Department, no. You know, that kind of seems to be what we hear a lot. And I think that's because it's pertaining to sensitive issues with the state having a high level of interest in the outcome of these particular cases, where Karen, Kelsey, for example, are you know, battling a system more than they are battling their cases. And that's what I felt like went on with the Karen Reed case as well, was Karen Reed was essentially taking on the system, and that's where the battle lied. You know what I mean? That's where the battle lied. And it's the same thing here. And these judges, they gatekeep it. And it's almost like you're not battling a normal case, you're battling this excessive against the system matter, where they don't want the police departments to be exposed for their shortcomings, and that they give someone like Bradel an extremely hard time. So are these judges corrupt? Your decision. It's my decision, right? It's up to our determination. But I would say this, as it pertains to these particular kinds of cases, there's obviously a level of bias. There's obviously a level of favored perspective against the defendant and the defense attorney. So again, corrupt is your call. Corrupt is your call. But yeah, there's no question here. There's nothing that you know, nothing here. What's to say here? I've seen it over and over, not just your neck of the woods. I comprehend what you're saying. I have jury duty for the 5th time in 4 years, but I want to be of service. I appreciate you, Maz. Thank you. Thank you so much. Appreciate it. All right. Let's get back to the action here.
Or not. But I am certainly familiar with the fact that even if that were true of a particular officer, it certainly is not admissible.
Judge, Graham McFarland has a whole host of things that are not admissible, or an optimistic defense counsel might say not yet admissible, but that's not a exclusionary factor, Your Honor.
Build a website.
Dollars right now, $245 has been donated so far today. So that's fantastic news. Total Defense Fund rolling in here. A lot of people coming in with donations, and we got $245 so far. Very happy with that. Funds keep rolling in for Kelsey Fitzsimmons. I'm going to add that to my overall total as well for all fundraisers. And this is fantastic news. So here we go. Yeah, it just seems like I said too much explaining away, which is kind of frustrating to watch.
You can't really go there. And these are all, we don't need to pretend like the officers are in Alaska. They're down the street.
No, I understand.
Commonwealth can ask them all these things.
But does that case say that all records pertaining to an officer, any officer who has ever invoked his or her rights, either under the Fifth Amendment or Article 12, records have to be kept and they have to be disclosed? Does the case address that?
It does not say anything about.
Does the case address whether or not an officer who is the subject of a pending internal affairs investigation unrelated to the matter that is before the court, that those records need to be produced?
Yes.
Okay. And what about whether the officer has ever testified in a motion to suppress, which the motion was allowed because the officer violated? It's pretty broad in terms of violating the defendant's rights, but assuming we could refine it a little bit.
Sure.
Does the case say that you must produce that? And who's charged with keeping those records?
Your Honor, Brady says we have to produce that. The Constitution says we have to.
On any motion to suppress that was ever allowed?
If an officer is found to be not credible, well, see, we're talking.
Well, hold on. Those are two different things here. The fact that a motion to suppress is allowed does not necessarily mean that an officer was found to have lied or made false statements. There are two different things. People make mistakes. The purpose of the exclusionary rule is to deter police conduct, but not every motion to suppress is allowed because a judge finds that an officer lied. Yes, the motions are allowed because in the court's judgment, for example, a stop was unjustified, but that doesn't mean that the court found that an officer lied. In fact, I'd say most of the time that's not the case.
We're not talking about a legal ruling about an officer's conduct. We're talking about when an officer has been found not credible. And that's what we're looking for, Judge.
Well, does your office keep records of decisions by judges saying that officers made false statements or are not credible?
Yes.
Okay.
And so,
Interesting response there, and I'm interested to hear that question again.
Officer's conduct. We're talking about when an officer has been found not credible. And that's what we're looking for, Judge.
Well, does your office keep records of decisions by judges saying that officers made false statements or are not credible?
yes.
Okay.
Yes, yes.
And so, and he's being accused because what he's writing in this motion is much different than what he's saying here.
Did you check the database for what I just outlined?
And we ask these officers, and he knows this, we ask these officers a whole host of questions.
Okay.
Whether they have convictions or convictions to show back about criminal offenses, and I'll just adverse credibility findings against them from any court.
Okay.
Pending criminal investigation into your conduct, findings that you were engaged in bias, racial, or
Okay.
profiling, discrimination.
Okay.
Findings that you have engaged in untruthful or misconduct and you're implicating credibility.
And have those questions been asked of the witnesses in this case?
Yes.
Have you provided any information that's responsive to those questions? So what's the complaint, Mr. Bradle?
Well, that's what I'm asking, is if it's complied with. And
You just said it was.
saying it was, and counsel got up and seemed to be wanting to correct me on that. And so here we are.
Okay.
So is it complied with or
Well, it's
not?
on the record. What else do you want?
The motion speaks for itself, Your Honor. I just want to know what the Commonwealth is objecting to.
Well,
They gave us a list and we can go through it.
the list of questions that you asked?
Counsel objected to 2C. Have they ever refused to answer questions citing their constitutional rights? We had a little bit of a debate about that. I think that's, Judge, a firing offense. I believe that assistant attorneys general have been fired for that. I believe officers have been fired for taking the fifth.
Really?
I think it's.
In the absence of transactional immunity, officers have been fired?
I think it's.
You should read Carney versus Springfield, and I think you'll find that you're incorrect.
Well, Judge,
This is quite the back and forth here between him and the judge. I think that's what kind of set off a lot of people about this judge.
I think it's.
In the absence of transactional immunity.
I believe that assistant attorneys general have been fired for that. I believe officers have been fired for taking the fifth.
Really?
I think it's
In the absence of transactional immunity, officers have been fired?
I think it's
You should read Carney versus Springfield, and I think you'll find that you're incorrect.
Well, Judge, I think that an officer that takes the fifth in this case about something else is saying, if I answer that question, a truthful answer will incriminate me. So I think under Graham McFarland, I think that's certainly
The case doesn't say it.
discoverable.
The case doesn't say it. I don't agree with you. Carney versus Springfield says otherwise, okay? And I don't agree. So,
No.
Mr. Gubitosi, have you provided a list of the questions that you have asked to the officer, or can you, or will you provide the list of questions that you ask to defense counsel? Okay. And Mr. Bradel, if the answer to all of those questions is no, and they've asked them, I'm not seeing anything that would indicate otherwise in this case, then you need to examine the questions. And if you feel there's something that wasn't covered, then you can refine your motion. But I am not going to allow, and I don't think I agree with your view of the law, that whether or not an officer is refused to answer questions, citing constitutional rights is something that you're entitled to. In the immediate aftermath of critical incidents, officers often advantage themselves of the fact that the police department does not have transactional immunity so that they can have an opportunity to speak, sometimes within 24 or 48 hours. Happens all the time. And in fact,
I don't know. What do you guys think? I mean, I just feel like this is like, I feel like Brado's trying to gear towards points, but then they're kind of debating, or someone said battling in the comments about other variables about these arguments. I don't know. I just think that I don't like the generalized response that, well, in a lot of cases, many officers have pled the fifth have been arrested. It's, then he's going back about other case laws or cases that have happened. But it's, I don't know. I just feel like Bradel's really, I find it hard to believe Bradel hasn't done his homework, and that Bradel's arguments or what he's citing are inaccurate in any way, shape, or form. But yeah, it's just frustrating to watch this overall. It is.
officers are often interviewed thoroughly thereafter. So the case does not say that if you refuse to answer questions, it is fireable. In fact, it says quite the contrary. The
I might
police
have said arrested. I meant fireable. My mistake.
department does not have the ability to grant transactional immunity. Only the Commonwealth of Massachusetts, the district attorney's office, or the attorney generals have that ability. So to suggest that a chief of police or commissioner could fire someone for invoking their rights without giving them transactional immunity is incorrect. And so as to the extent you're asking for that, it's denied. Now,
The next one is D.
yeah,
Whether the officer is subject of a pending internal affairs investigation or any internal affairs investigations into the officer's conduct, whether.
Pause this here. We have hit $300 in donations. Thank you very much, ladies and gentlemen. $300 in donations for Kelsey Fitzsimmons. GiveSendGo. Thank you, guys.
These have resulted in sustained findings of misconduct. I'm not sure why there's an objection there.
Well, the way it reads is different than the way he said it.
okay,
If there is a sustained finding, absolutely.
sure,
And,
okay,
and there hasn't been in this case. So
okay,
with any of the officers that are involved.
okay. So that's the answer to that. And as far as the other questions, it seems to me H and I are covered by the questionnaire, but J,
Oh, no, H, if I might just say this, H and I, you're gonna deny them, but they're different than what he's saying.
no, I is only, you only need to respond to I if there's been a finding by a judge that there was a misstatement in the search warrant affidavit, not whether or not defense counsel has filed a Frank's motion, because that happens routinely, and routinely the matters don't even reach an evidentiary hearing. And even if they do, it often doesn't result in a finding that there was any untruthfulness. So yes, if there has been a Frank's finding by a judge that an officer, any of these officers, made false statements in a search warrant affidavit, yes, you've asked about that, and yes, that has to be produced. Okay.
But H, if we can just get back to that.
Yeah.
Because I'm talking about that a little, and if the way counsel is talking about it, if there's been an adverse finding of credibility, course we turn that.
Yes,
That's a no-brainer.
Right.
We do that. But that's not what that said.
no, not I am not going to order the production of any motions to suppress that were allowed for any reason. First of all, it's almost impossible to ascertain that. And secondly, how many district courts in this county, Mr. Gubitosi?
7.
7? Well,
Yeah, but you can ask the officer, Your Honor.
Well,
Officers.
he has, and I agree with you. If there was a finding that the officer made a false statement, you're entitled to that. But the fact that an officer thought that he or she had reasonable suspicion to conduct a pat frisk and a judge disagrees does not mean that the officer was found to be untruthful. Like, yes,
Ugh. I don't know. I just think that Bradel really wants to be able to ask questions or be able to have questions asked of an officer to ensure that they were actually talking or answering questions with accuracy. And I think that that's what the back and forth here really is all about, is that it's kind of, can we just get to the bottom of this, please, 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 please. You know, it's just frustrating to see they go back and forth. I don't think this judge is always negative. But there's just some times where it's like you kind of hope for this judge to be a little bit more accommodating to the defense as well, you know, as opposed to necessarily more favorable towards the prosecution, as we've seen. So, unreal.
in the course of
need to debate it. I agree with you.
Okay, so I think we're fine. Now, Jay, you know,
I just have no idea.
I have no idea what that is.
No one asked you, prosecutor. Sit back in your chair. He sits up for no reason. Watch him stand up.
Debate it.
Watch the prosecutor.
So I think we're fine. Now, Jay, you know,
Here it comes.
I just have no idea.
No one asked you. Sit back down, Mr. Prosecutor.
I have no idea what that is.
Okay, and then they can answer that. They don't know about it. They don't know about it. That's the answer. I'm happy with that.
Okay.
All right, we're over $300 in donations so far, so we're rolling there. Very good job, everybody. Let's see if anything else came back in for donations. Oh, holding out, $300 on the spot. Great job, everybody. Getting there. Okay? Very happy with everybody's donations. Sit back down in your chair, Mr. Prosecutor. Nobody asked you. But no one asked you, Mr. Prosecutor. Sit back in your chair. But no one asked. Sit down, Mr. Prosecutor. I'm just like, no one asked you. Sit the hell back down, Mr. Prosecutor.
Is there, Mr. Gubitosi, when did you get meeting 35, the motion for specific discovery? Okay. Are you prepared to respond to it?
I can try to reject.
Okay.
You can try or you can do, Mr. Prosecutor.
Is there anything in there that you object to?
Yes.
Okay, and what is that?
Again, there are portions of number 2.
I said sit down when you speak. No, I was kidding.
And I will provide all witness statements.
Okay.
14, this is overbroad.
Okay.
Number 4A, 4 is asking for any and all footage from the North Andover Police Department on June 30th, during the time in which Ms. Fitzsimmons was at the station. We've already talked about that. They asked me a bit ago. They didn't ask me in time, so the footage is gone. But it just doesn't save longer than, I think it was 30 days.
Okay. Well, if something doesn't exist, and
But the last paragraph, the last sentence says, the name and contact information of any officer that interacted or observed Ms. Fitzsimmons at the time.
okay,
Well, she had that information. Who she interacted with.
Right.
Number 30th to 5 at the station, so that's something.
well, first of all, maybe I'm missing something, but other than in the interview room, when someone's advised that they're being recorded and you know, they're taped, I'm not sure there's,
No, I think this is, she didn't go to the PD after the event. She went to the hospital.
okay,
For the event, it's my understanding, and this is only from what defense counsel told me.
Yeah.
That she was at the station earlier that day.
oh, okay.
Had, done something. I can't remember what during the day.
Was at the station earlier, Mr.
But she
Brady?
knows who she interacted.
Okay, is June 30th, the date of the incident, by the way?
She was at the police station earlier that day. That is correct. It's just frustrating. I don't know. It's just frustrating. Overall, it's very frustrating just to listen to all this. I apologize for mocking, just having a little fun there for a minute there. I probably should be more serious throughout the show, but sometimes I just need to unload with some comedy because it's a tense situation. But, I think it's just frustrating to see all this go down and the way it's gone down without any level of, I just don't see why Kelsey has to sit in jail as opposed to sitting at home under house arrest. When this is all related to alcohol testing, this is all related to alcohol. The whole reason why she can't even sit with her attorney right now is because of alcohol testing. She was shot, unable to do the test or unable to do it without pain. And because of this, the other judge just sends her to jail and she misses her birthday and she misses Thanksgiving. It's like, come on. It's yeah, exactly. She needs to be with her baby too. Correct. It's just frustrating to see all this go on. Like I said, worst case scenario. At least she's under house arrest. Worst case scenario. Not this, having to be sent back in a van back to Western Massachusetts and hauled back and forth from court every couple of weeks.
Okay. And when was she at the station and for what purpose? What time does the incident happen?
So Your Honor, the incident it's in the afternoon of the 30th. And prior to that, Ms. Fitzsimmons was at the North Andover Police Department for a CPR recertification.
I see.
She brought the baby with her.
Okay.
So we wanted the video
Yeah.
on the station.
Yeah.
And on August 26th, I think the Commonwealth's going to have an issue with this, okay? On August 26th, we filed these arraignment motions.
Right.
Asking, we put them in abeyance except for some of the more obvious ones like preserve notes, preserve video.
Sure.
Tell people who are video holders to hold on to the video. That was August 26th. So the Commonwealth was on notice as of August 26th.
Yep.
The video, I am fairly certain, was present and available then when they were given notice of this motion. And I believe the court allowed those preliminary requests.
Well, there are two issues there. First of all, though, when you say August 26th, was that filed in this court?
Correct.
When she was arraigned?
Yes.
Okay. And Mr. Gupatosi, do you know, first of all, I don't know because not that familiar with the North Andover police station, whether or not they even have cameras that would have videoed the presence of the defendant at the station on that day.
They do.
Okay. And do you know how often those?
I know. That's a good point. The judge makes a good point. Would they or would not they have footage of her actually being there at the police station on that day? I'd imagine they do. I just still can't get over the fact that they didn't have body cams on when they went to the house, when they delivered that RO. That's what's really controversial here, considering that police department was granted the funding to pay for body cameras and have body cameras on, which would clearly show if Kelsey Fitzsimmons had done anything violent towards Officer Noonan, that it would show clear as day. It's the same argument with the Karen Reed trial. It's if she backed up and hit him, show us some ring footage. Show us some ring footage that shows us that Karen Reed did it, and we'll go ahead and say, okay, no question about it. Karen Reed backed into John O'Keefe, but that's never produced. There's no body cam footage of them going to her house at all, Kelsey Fitzsimmons' house, and making any arrest or showing any footage of her pulling a gun on them. None of that's ever produced because they had no body cameras on. And I just see this is why I just think body cameras need to be mandated in the state of Massachusetts. It protects everybody involved.
Those are recorded over.
Not at the present time.
Okay.
I did. When we spoke about it, I called.
Back in August?
It was gone. I can't remember.
Okay. So the issue then becomes whether or not the request was made, first issue is whether or not you're confident the video doesn't exist today.
Correct.
Okay. The first question is, I think that the defense counsel's entitled to know when the video, how often they tape over. I mean, I hear,
I did tell him that
right,
when I found out. I just can't remember right now.
but you
I
can,
can just suggest, Judge, if I
Yeah.
may, I looked at, counsel's trying to accommodate, so I
Right.
appreciate that. But on 9/18, counsel told me that they only had it back to July 5th,
okay. And you made the request on,
26.
right, but that doesn't answer their last question, which is whether or not at the time you made the request, it still existed or not.
Right.
But Mr. Gubitosi, that should be easily ascertained. Sure,
I
okay.
think if you do the math, it looks like it is. And again, I appreciate the Commonwealth's effort.
I want to talk about the footage at the police station in North Andover. That was a great comment by the judge, I felt, was that Bradle is entitled to know how often those loops are taped over and how long those cycles are on the cameras. If that's how their operation works, or if it's a constant like digital recording of everything that's going on over there. But yeah, it's I don't know, Debbie. I just don't know. I just don't know. We get another $10 donation in for Kelsey's defense fund as well. Thank you for that. $310 towards their GiveSendGo so far. Yeah, it's I always wonder what footage is available, what footage is not available too. That's another thing I also think about, frustrating.
To try to get it. On 8/26, if you do the same math, 9/18, it goes back to July 5th. 8/26, you're going to be within the window of.
You may, I don't know. I don't have every video system that I've ever heard of. I've seen some that go 3 days, 7 days, 30 days. I don't know, but that's easily ascertainable. And Mr. Gubitosi is going to tell you about it, and then you can make of it what you need to make of it.
And there's no motion before
Mr. Gubitosi, tear down that wall.
the court on
Yeah.
it. I just wanted to
Okay.
bring it up, Your Honor, that it's very important to the defense that we have that
All right.
video.
Anything else we can, in this motion, Mr. Gubitosi, that you object to that we can address today?
Yeah, I can do that.
Bacon.
All right, so yeah, $310 right now in donations for her defense fund, which is GiveSendGo, which is fantastic. I'm checking right now to see if anything else came in. Not yet, but we're rocking $310 here on a quieter fundraiser with short-term announcement, which is great news. So happy about that. We're going to go a little bit while longer here today, and we're going to get this video fired back up. But yeah, I think that's interesting, again, how often the cycles of camera footage are on the police stations. And once again, the defense is, filing motions for everything they can here to get as much data that they can use for the defense as possible.
Number 6 is concerning disciplinary records for firefighters that responded to the home address of the defendant or the Mass General Hospital.
And your objection to that is?
The firefighter cannot harm the prosecution team if they're not in care, custody, control.
Yeah, I mean, you can file a Rule 17 for that, Mr.
Very good, Your Honor. That's perfect.
I think that's right. What else, Mr. Gubitosi? Anything else in this motion?
Number 9.
Yep.
You see Kelsey here. It hits me every single time just how frustrating this is for her to have to go through this whole process. And knowing in this particular hearing that there's no chance of her going home on this day. It's very frustrating as well to be there, sit through this, listen to all this stuff, all the back and forth, lawyer and prosecutor, defense attorney and prosecutor, saying what answers, questions, motions, whatever that's going on. Dealings with the judge, she's sitting there and it's just the end result of this, no doubt, rolling through her mind. And then again, not being able to see her child, who she hasn't seen in a long time, which is extremely the most frustrating part for all of this. And that's really hard to see her go through here. And just knowing that no matter what happens on this particular day, she's going back to Chicopee to be locked down through the holiday. It's extremely. Yeah, and having to stand the whole time, Diane, I agree. That's also frustrating as well. No opportunity to sit down and just relax her body at all. it's extremely frustrating. The whole thing all around is very frustrating. And for her, again, this is all the stuff's racing through her head. She has a long-term outcome that she's focused on for all of this, which is being basically declared not guilty of firing at an officer. And I think that's another reason why the whole gun jam story came in too, because they couldn't justifiably say that she had ever fired the weapon. Oh, the gun must have jammed. That would give them justification to fire at her. Just a wild story.
All statements, including text, email, voicemail, writings, or light between or any civilian witnesses, police or prosecutors. I would just say it's overbroad.
Yeah, Mr. Bradel, how can the Commonwealth produce messages between people who are not, civilian witnesses?
Sure, I understand, Your Honor. The request should be really a little narrower, I suppose, which is whenever there's a police prosecution team member in the conversation,
Well,
then
that's
it
different.
should
I
be
agree.
discoverable.
Right.
So
So statements, Mr. Gubitosi, of people who are,
There are statements that
Yeah.
I'm obligated to provide.
Yeah.
Absolutely. I agree with that, but not that.
and just, oh, sorry. Go ahead.
No, I was moving on.
Just the one thing on that before you move on, Your Honor, is
Yeah,
that,
yeah.
it's our view, we viewed on the security video from the scene that officers are texting and calling all over the place at the scene, quite understandably.
Sure.
But we just want the text messages.
The text messages are key. This is important. This was in their recent motion as well that they filed, Tim Bradel's office, that having this access to these text messages is important. And this really goes back to Michael Proctor as well, in the case respective to the Karen Reed trial, is the same understanding here. They were texting at the scene. What were they texting about? Were they just texting about, random stuff in their lives, work-related stuff, or anything related to Kelsey Fitzsimmons and the fix being in? Now, I think that's exactly what Bradel's trying to narrow down here, is they want access to those text message records just to see what was talked about. Was there a fix in? Is there anything that could suggest that, hey, just say that the gun jammed or something? Is there anything that relates to what happened inside the house, which is definitely information that is absolutely important to Kelsey's defense. So it's a great, great motion there, or argument there by Tim Bradel.
And we have information that there were communications between the father of the child and the police officers.
Yep. So that's huge as well. Communications between Justin and the police department. And again, that's trying to narrow down what was discussed. And does that discussion have anything to do with anything beyond the coordination of the RO being served? And I think that's what Bradel's kind of looking for right here. Is there anything that could shed light on anything to suggest that this was a fix? Like many suggest.
Leading up to serving this warrant, leaving up the restraining order, serving the restraining order, leading up to that. And there are communications that are between the father and the police that we want,
well, if
which would
any
certainly
of
be
those
safe.
materials that are in the possession, custody, or control of the Commonwealth or the North Andover Police Department need to be produced. I can't, it's a little bit broad in the sense that, if there are people texting that the Commonwealth doesn't know about.
I saw you, Judge. I don't even want to, I can cut to the chase on that.
Let me
Same
suggest
that involve the
something
police and prosecution team.
here. I'm well aware of the fact that there's some discovery issues here, but they don't seem insurmountable to me. And they seem like something that could be worked out. The defendant's in custody. You are and have, as is your right, litigating the issue of her detention. And my solution to that, it's not my decision one way or the other, but it's in front of the SJC. But I feel that this is the type of case that is tried in the district court every day. It's a serious case. All cases are serious, but it's not complicated. And I want to set a trial date sometime early next year, and we'll get another discovery compliance date in a few weeks. Mr. Gubitosi starting a trial December 1st. So maybe in late December, we can have another compliance date if it works for everybody to try to iron these things out because, she is in custody, cognizant of that. And so my solution, whenever, and we deal with this all the time, we spend sometimes more time dealing with the issues of pretrial conditions and release. And in the time we spend doing that, we could try the case. So this case looks to me.
I actually will say this. I do like the idea of going to trial as soon as possible. I do like that argument. But I think someone just said it here. Serious but not complicated, cut and dry. I don't think that I think this is complicated. Maybe not in a legal sense, but I'd say the case of it in itself is complicated. But I also don't want to see this thing rushed to trial. I don't want to see this thing rushed to trial and the defense not have everything they need or all the access to evidence that they need either. And I don't know if there's, I do think going to trial sooner is better, but only if the defense has all the materials that they need to properly present the case that they need. I don't want to see a situation where they're going to trial on this, and it's similar to the Karen Reed case, where the Karen Reed case goes through two trials, and there's still information coming out later down the road that wasn't even able to be used in the first trial. And the only problem I have here, I think, is that it just sucks right now because Kelsey's still in jail. And if this trial takes longer to go down, then that's probably longer. So she's going to have to stay in jail, which is like kind of the catch-22 in all of this. It's almost like, well, it'd be good to go to trial as soon as possible because that would get Kelsey acquitted as soon as possible. But if they go to trial and they don't have all the information, that's also going to affect the defense's ability to properly get a clear-cut ruling from the jury as well, potentially. They want to make sure they have all the information. Defense, this GiveSendGo is now up to $320 as we speak. $320 as we speak.
I could be wrong, that it could be tried in a couple of days. And she's in custody. So if the case is tried and she's found not guilty, that's the end of it. If the case is tried and she's found guilty, that's a whole other issue. But the fairest thing, it seems to me, is to try the case as promptly as we can. So before your schedules get any more backed up, I want to set a trial date and always revisit it. But what about sometime in late January, February?
That's very fair, Your Honor, and I appreciate you saying that. And
yeah, like I said, I want this as soon as possible too. But I don't want a situation in which, this thing is, again, have everything that they need. You know what I mean? All right, we're gonna get this thing fired back up. $320 so far in donations. And we're hanging out pretty good there. So there we go. All right, let's get this all back up on the screen here.
I wanted to ask maybe the first week of February.
Sure. Mr. Gubitosi, how's that work for you?
I have a murder starting on the 26th of January. So if we can go to, I could do this the week of the 9th.
Okay.
That's fine.
Does that work for you, Mr. Braden?
Yes.
Is Attorney Copley?
Always with the caveat that I haven't checked with any witnesses.
Of course.
Sure.
And but this way we have a target date. Everybody can check with their witnesses. We can find out and iron that problem out now. And if there's somebody who needs an adjustment for a few days, a week, one way or the other, we can work on that. But the longer we wait to do it, the more backed up we get. And again, we're going to prioritize this case. She's in custody. Maybe she will be at that time, maybe not. I don't know. But at best, for your client, she's going to be on restrictive conditions, and that's a factor as well. So let's get a trial date now. Let's shoot for that. We'll schedule it for trial on February 9th. I think that's very reasonable. And let's set another discovery compliance date that everybody can live with sometime in December. Mr. Gubitosi, you expect to be tied up for a couple of weeks?
Yep. I think I can, week of the 15th, I should be.
Okay.
I'm just going to ask for.
I'll say this. I do think, like the judge or not, I do think that getting this scheduled as soon as possible is a good thing. And if they need to push back the trial date come February, they can always do that. But if they can narrow down that day now, at least, if they're all ready to go by then, they can roll with it. So I think that that's actually a good thing in my particular opinion, because I think that you want, because this happened to the Karen Reed trial. The trial was supposed to start at a certain time, but it got pushed back a few times. I think both of them did. So I think actually last year's trial was supposed to start in the winter. I think it was supposed to start in January 2025 and didn't start till May or April. So that happens as well. So we'll let this thing roll, and hopefully everything's ready to go, and we can start getting exactly, Broken Baker. Just get it going, get things set up, and just try to push this thing with ready to go for trial. And hopefully everything's ready by that point. It doesn't need to be pushed back, and we can get Kelsey through trial, and hopefully she's ready to go with this and can move forward with her life as an innocent woman, which she is.
Maybe the 18th along those lines. I think we're on the same thought process.
We can do that. Sure. We'll do the 18th. And my purpose that day.
Sorry, Judge. Just a calendar issue. I'm sorry.
Oh, okay. All right.
It's a tough day. It turns out. Can we do the 19th?
I'll do it.
Okay.
If Mr. Gubitosi's available. Okay. We'll do it. Now, and I want you to have a conference, which I know you will, to see if you can work these things out or refine or narrow the motion. And we'll revisit those things that day, Norfolk, that we have to get to right now. So it's either that or we get together late this afternoon.
We're fine.
Okay.
I think we can resolve much of the rest of it.
Now, as far as your request, the last thing I'm going to cover is your request regarding transportation of the defendant. I allowed it today. I'm going to do it on a date-by-date basis. I mean, if the next date is discovery motions, I don't think that it's necessary to transport her. If you want us to try to do a Zoom, we'll attempt to do it. But the goal here, again,
the Zoom meeting would be nice, in my opinion. I mean, I'm sure Kelsey doesn't mind having to get out of that solitary confinement cell, but at the same time, it's a heck of a long ride. So Zooms might not be the bad idea either, just to kind of keep things moving forward here. So she doesn't have to keep getting dragged to court. But I want to see her out of jail as soon as possible. This is just really sad. I like to see, like I said, worst case scenario, home arrest until this trial is over and done with. It's a come on. Yeah.
fairness to the defendant and everyone else is to get the case tried promptly. So we'll have a hearing that day. I'll try to, or me or someone will iron out all of these issues if we can, and let's keep moving. I don't expect, doesn't sound like you intend to litigate a motion to suppress in this case.
Correct.
So that removes one common obstacle to getting this done. So working with that, I think everybody's being reasonable.
So it's roughly, with no traffic, it's about 2 hours. And then if you take into the fact that there's Massachusetts traffic, yeah, it gets right up to about 2.5 to 3 hours, somewhere in there. It's a long drive. It's a long drive. Yeah, it's long. Yeah, it's a while. It's a ride, to say the least. We're up to $325 in donations, folks. Thank you.
In terms of time, why don't you have a further conference, exchange written responses so that there's down the road, there's no misinterpretation, and let's see each other again in a few weeks. And I'll order a Zoom, Habe, if we can do that.
Thank you.
Okay?
If,
All right.
I think that'll be fine. If there's any issue, we'll file a.
Yeah, exactly, Broken Baker. So it's just two to 3 hours, we'll say, based on traffic, one way, not including the ride back. So you're right. It is like 4 to 5 hours roughly of traveling. It's a haul.
And if you have a narrower motion, or you can narrow the issues, file another motion, and I'll make sure that I get a look at it, or somebody will.
Thank you, Your Honor.
All right, thank you. Have a great holiday.
All right.
All right, thank you.
Likewise.
Same to you. Okay.
Judge, would that be 12 noon as well, the same thing, or does that?
My boss has to tell me that right here. Okay, she says noon, then that's, we'll do it.
Thank you.
Okay.
Welcome to the Shopper.
All right, we're going to switch over. Kelsey departs court here. You know, seeing her mom for the last time before Thanksgiving, which is sad as hell. I'm just going to get set up for the next screen here. All right, we're going to watch Justice Served TV. This is Justice Served TV. Michael Bryant in his interview with Kelsey Fitzsimmons' mother, and I believe this is her stepfather, I believe here. So this is going to be their interview with Justice Served.
Here, this is before the hearing. We're most interested in how Kelsey's doing. Yeah.
I think she's had some ups and downs. You know, last week was her birthday. This week's Thanksgiving. You know, we're pushing on to the Christmas time frame, and you know, she's a fighter. And you know, some days she may be down a little bit, but other days she comes back fighting. So it's
yeah, it makes perfect sense. I mean, I'm sure there's days where, you know, you have levels of optimism. You know, as a human being, you're going to have your levels of ups. You're going to have your levels of down. You're going to have your time where it's like, I'm going to fight through this. I'm going to get this. And there's other times where it's hopeless. It's hopeless. The psychology of spending time in jail like that, day in and day out, and literally hoping for the clock to run out in terms of getting to trial or getting out of jail, time just stands still, I'd imagine. And it's extremely frustrating, and it's a hopeless thing. And all of this hanging in the balance is seeing her own child, of course, which is also very, very difficult and heart-wrenching as well throughout this entire process.
Here you get some Zoom time.
Yep. We get 2 hours a week on Zoom, and yeah, that's it, 2 hours.
So 2 hours a week on Zoom. And you think about some of the things, too, that it's not always just going to be catch-up time, you know, where they talk about, you know, how are you doing? How are things there? You know, it's a lot of it's going to be about like arrangements, like, you know, it's not always for psychological, you know, reasons as well, like just talking to someone, talking to your mom, talking to your daughter. You know, it's about like arrangements too, like, you know, certain things that need to be done or other things they're working on behind the scenes and all that, custody battles, all that stuff that I'm sure that time's being used. So 2 hours is a very limited amount of time, you know, and if you use up too much of that time, say in a given day or two, you're not going to have enough time for later in the week as well. So that sounds like it's very difficult to maintain. 2 hours is not a long time. It isn't. It's not like maybe if it was like, say, 20 minutes a day, you know, at least, which would equate to what? 2 hours and 20 minutes, I guess. Well, I guess maybe you can do about 20 minutes a day, 15 minutes a day, you know, if they're allowed to break it up. But, you know, that's tough.
You make of that? I mean, it's got to be brutal just to be that distanced. I mean, how's she doing?
She's a fighter. She's hanging in there. She has wonderful support and community support. That's what's keeping her going. All the love and support that she has.
And you know, you're talking about your daughter. She's in jail without her son. Can you give them perspective?
It's horrific. She hasn't seen her baby in 5 months, and it's awful. We've tried to see him and have been denied, and baby that we saw almost every single day.
So there you have her own parents that have to go to the court system, the justice system, just to see their grandchild. That's how leveled this thing is with how many layers there are to this whole thing. It's
Why do you feel that's being, you know,
and you can just tell that this is taking an extreme toll on her. You know, this is the worst situation. Her being a mother, seeing her daughter in jail, having just seen her daughter hauled away back to jail, not even able to see their grandchild without having to go through the court system. This is something that's extremely difficult, all because their daughter got shot. And all because the claim is that she allegedly pulled a gun on officers. This is very difficult. This is why it's so important for us to raise money too. And guys, we've raised $345 during this stream. Thank you guys so much. $345 added in to Kelsey Fitzsimmons GiveSendGo during the stream, guys. Fantastic.
Used against you. I mean, what's the allegation?
I wish I could answer that. I have absolutely no idea.
So what's the status on that?
So right now it's we get the order back from the court where we could serve Justin, and everything's out in process, and we're waiting to receive the paperwork back so we can get it back to the court.
Have you heard from the father why he doesn't want or has been fighting visitation?
No, I don't. I'm not really sure how the restraining order works, but if it hurt Kelsey, and we're not looking to do anything like that. So we've had no contact. Yeah, we just do the right thing and try to go through the court system and work how we're supposed to.
All right. Well, maybe some good news today, and I hope we can talk after.
All right. So that's that. That's that with the interview. And again, you just feel bad for the family right now. Obviously, you can tell a lot of hands are tied. There's only so much they can do, but they are doing everything they can do, which is the most important part. We're going to take a look here. So our donation fundraiser total for today is $345. All right, so $345. And that's it. I actually have had a major headache throughout this entire show that I haven't been really visibly showing, but I am battling a headache. So that's it. That's going to be the show. About an hour and 40 minutes. Like I said, I'm battling a headache right now. I'm feeling right in here. But, we raised some money today. It's fantastic news. We'll be back next week. We're going to do a bigger fundraiser next week. We're going to have some guests and everything and do everything we can to just build up funds for Kelsey and help her out. But, guys, thank you so much for your time today. And I'm going to grab a quick screenshot of this as well. See the talking. That's the original MazzaMedia right there. All right. Got that. And we're good to go. So, guys, have a great afternoon and take care of yourselves. Free Kelsey Fitzsimmons. We'll continue to do our work and help her out. And, yeah, thank you so much. I'm going to probably take some Tylenol as well here shortly. But, guys, thank you so much and have a great afternoon. We're back to the week and continue to pray for Kelsey and everything else as well. And we should be good to go. So, guys, pray for Kelsey tonight every day. Continue to raise money for her. And do everything you can. I'm just going to check the donations one more time. All right, $345 is our total, and we're good to go. All right, guys, take care of yourselves. Have a good afternoon, and we'll see you guys soon again. All right, from MazzaMedia, I'm Mark. Be sure to subscribe, and thank you guys for your time. And write letters, exactly. Write letters to Kelsey, guys. Perfect. All right, thank you, guys. Have a great afternoon. Bye-bye.